The major change in Tallahassee, taking away the fee shifting, has very, very severely hampered any individual person's ability to sue their own insurance company for an insurance claim. I don't know why an insurance company would approve any claim under the new system because we no longer have the hammer of potential fees.
You've disincentivized the insurance company from actually paying claims, is what it
Right.
seemed like. And it's disincentivized any attorney from ever taking on any case unless it reaches a certain size.
Had enough of excessive fines, selective enforcement, and nosy Karens? Welcome to the Association Nightmares podcast. If you're tired of being pushed around by your HOA or condo association, you've come to the right place. Property owners, get ready to take back your power. And now, here are your hosts, Ann and Mark.
Welcome to the podcast. Today we have Jeff Donner on the podcast. Jeff is an attorney with 25 years experience handling civil litigation matters in Florida. For the last nearly 8 years, he's exclusively represented property owners in first-party property insurance cases against their insurance companies. He's recovered $19 million in those cases since 2017. Jeff wrote an incredible blog post about the changes in legislation that affect all Florida property owners. It was entitled "The History and Philosophy of Fee Shifting Statutes in Florida." It was really eye-opening for me. And that's why we reached out to him to invite him to join us in the podcast. Welcome, Jeff.
Thanks, Mark. Pleasure to be here.
I was very impressed by the article as well. It was really mind-boggling.
Well, thank you, Ms. Hirsch. It's interesting because a lot of this stuff in the article, I didn't know until I did the research while writing the article. I'm sure we'll get into that, why I was inspired to write it, and it made me learn some things.
What inspired you to pursue a career in law, particularly in consumer and insurance law?
As far as I know, I'm the first lawyer in my family. I didn't have family members who were lawyers influencing me growing up, but I was a baseball player. Dad was the coach. So I'd have to say my dad influenced me to be competitive in general. I think it allows me to get that competitive drive satisfied, even though I'm not playing baseball anymore.
Mm-hmm.
I wanted to help regular people. You cannot succeed as a lawyer unless you really do want to help people. I just enjoy more having a client. Mr. Smith is my client, and we go to court and try to win the case.
Well, I appreciate that. As someone who was a self-litigant, I do appreciate when there are attorneys who care about, people who don't have the funds that the insurance companies have. How has your experience shaped your views on access to justice and the need for legal protections in Florida?
Well, the last 8 years, I mean, it's just, I could not overstate how much, because what my article was about, and I think we might get into this a little bit later, is in Tallahassee, they've changed the law where if an insurance policy was incepted after March 24, 2023, there's no more fee shifting, which fee shifting is the legal term for if you sue an insurance company and win, then the insurance company has to pay your fees separately. And that's truly separately, as opposed to like taking 33% of a recovery, which is what we're having to do now.
So you work at contingency then, correct?
Well, now we're having to do that. We were always on contingency. We learned on day one in law school, we follow the American rule, which means each side pays their own attorney's fees. Turns out there's about 57 exceptions to that. And in the real world, you don't always find that. So fee shifting allows individual type claims to be able to go up against the big, wealthy, either insurance company or other corporation that can pay its people by the hour.
Let's talk about the change in Florida statute. So could you tell us exactly when that change happened and which statute they changed?
Okay. I'm not going to be able to say the exact. There was 627.407 or one of the Florida statutes completely disappeared. Let's go back 5 years. They were tinkering with changes since 2020. As of March 24, 2023, if a policy was incepted after that date, they erased the entire fee shifting statute. So that's every case now, because as we know, insurance policies renew only 1 year at a time. So now we're already, like, every case I have right now that would come in would be under the new system, because the insurance policy would have been incepted after March 24 of last year. There's still this thing called a proposal for settlement or an offer of judgment, and both sides can do it. So if my client does a proposal for settlement and there's formalities you have to follow to the insurance company that says we'll settle for X amount of dollars, and then they don't accept that, and then we beat them in trial one day, survive all the appeals, it's 3 or 5 years later, If they didn't get within 75% of our offer, then they'll be liable for our fees. For us to make a proposal for settlement that would actually scare the other side, we wouldn't want to accept it because the fees aren't in there anymore. The
Right.
fee used to be a claim that it's a remedy. You could think of it as a separate claim that my client was entitled to.
Mhm.
So I could give an example. I think Mark mentioned I've actually settled cases recovering a little more than $19 million since March of 2017. About 13 million in benefits and about 6 million in fees.
Mhm.
All of those were done under the old system where those fees really were paid separate. You mentioned contingency. When
Mhm.
clients hire our law firm, the retainer agreement does say we're working on contingency, and it says we get an amount, if there's a settlement, we get an amount awarded by the court or 33%, whatever's higher. But historically, and sometimes it takes some tactful counseling to let my clients understand, 99% of cases settle without a trial. Or even after a trial, they'll settle to avoid appeals. I have done 4 jury trials in the last 3 years. All those settled even after the jury verdict. If the insurance company historically under the old system, because they were afraid if we beat them in trial, we could have a $150,000 fee award if we got our client $1. Literally. That's not us taking a percentage. I'm giving you the speech now I give my own clients when we're signing them up.
Yeah.
$1 above deductible. We could go to trial, win our client $1,000, and our fees could be $100,000. And the insurance company knows that.
What you're telling us is that before the change in the legislation, because you knew that you could ask for legal fees from the insurance company, that gave your clients more leverage in getting settlement. Is that what you're saying?
Exactly, perfect way to say it. And a lot more. I mean, it matters.
Okay, so now that the legislation has changed, tell us what the difference is and how that's impacted your clients and your law firm.
Well, the difference is so huge. I don't think it's possible to overstate it. I can give an example. Right now,
Please.
I have about 30 cases, pending cases that are in suit. Lawsuits been filed under the new system.
Okay.
The insurance companies and their lawyers, of course, are aware of the new laws. It matters. When we would settle a case before, part of the settlement offer does include our fees because the insurance company knows they owe that under the old system. And it
Right.
wasn't really us taking 33% of the total. Like they would offer, let's just, for an example, the 80,000 global, we'd call it. Sometimes it would be up to me to really kind of remind my client, but it's like, look, they're offering you 50,000 benefits and 30,000 fees and costs. And that's case would settle. That's the average case we'd get the clients 30 and we'd get 15 actually is a more average case. 30,000
Mhm.
benefit, 15,000 fees. If you do the
Okay.
math on all my cases, you'd find that. Under the new system, the fees are not owed separately. It matters. I have a case right now. I kind of mentioned it earlier, not naming any names, so I guess it's okay to talk about it. It's a plumbing leak case. The client spent a pipe burst in the wall, water everywhere. Clients fixed the bathroom for $10,000. It's not a cast iron pipe case. You might have heard of those. We can't really claim that all the pipes throughout the whole house have to get redone. It's a bathroom. They fixed it for $10,000. There's an $8,300 deductible. The offer is $1,700. Global. But global is not even the correct terminology anymore because they don't owe our fees separate.
Mhm.
So that $1,700 claim is a small claims court case, literally $8,000. I mean, it's $50,000 to get in
Sure.
the circuit court now. County court,
Mhm.
the mid-level is between 8 and 50. These cases land on my desk. I wasn't there when the client was brought in. You also asked, how's it affecting our firm? We're
Right.
actually thinking the client should have been told we can't take this case. You can't take a $1,700 case on contingency. Historically, they would have been afraid of us because, by the way, the insurance company denied, paid them zero. So it's
Mm.
another example where the insurance companies nowadays, they have no incentive. I don't know why an insurance company would approve any claim under the new system because we no longer have the hammer of potential fees. Historically, they would have known they should have paid my client the $2,000 they owe her. We could get 100 back to this. We could, if we beat them in trial in such a ridiculous little case, 2,000 for the client, 100,000 fees. We would settle that case easily for $25,000 historically. The client would get 15,000. We'd get 10 for our fees.
I just want to make sure I understand this. So with the same numbers that you're talking about, $8,000 $10,000 repair on the bathroom, they have a $1,700 claim. So under the old system, if you took the insurance company to court, you could recoup the $1,700 plus the legal fees. Yeah.
That's exactly right. Well, it's not set in stone, but I keep using the number 100,000. If you were to win after a trial, the risk to the insurance company would have been an award of like 60,000 for the fees
Right.
on a $2,000 plumbing case. And that is to keep the insurance companies in line. They shouldn't wrongfully deny claims. There's this threat of the fees.
Yeah.
So under the new system, that's just gone. They can fight us in court for 4 years, offer my client that same $1,700 the minute before the trial is about to start on the courthouse steps, and there's no penalty of having to pay our fees. It really, I hope they're not listening. We are internally thinking, that Tallahassee has won. They're trying to shut down what we've been doing.
All right, so is it possible that under this new system that the insurance companies could basically deny a claim completely and not pay out any insurance claims? Is that possible?
Yeah. I mean, it was always possible, but insurance companies do claim to want to try to do the right thing, and they don't just deny every claim. But on the closer cases, if they did decide to just deny every claim, the policyholder would face the problem I just described. Is a lot of the value of the claims are less than $50,000. A lot of claims have value less than 50,000. You can't have a lawyer do that on contingency. We were supposed to be getting our fees paid separately. And yeah, that is a way to keep the insurance companies honest.
We'll be right back after a word from our sponsor. Property owners, the best way to stand up for your rights is to become a member of USCFAR. Visit us at www.uscfar.com now.
So I was looking into this myself, and what I found that really surprised me, I was looking at what kind of press coverage there was around the change in legislation. DeSantis signed off on these bills, and it was called tort reform. And I think that was actually billed as consumer-centric tort reform. What I found through all of my searching online is the bills were only covered in industry media. They were covered by lawyers, it was covered by insurance agency, property management. So only within the industry was the story really carried. And it made me wonder, why would there be no consumer media coverage of this change? It affects every homeowner in the state.
DeSantis's argument, and the people that agree with DeSantis, his only argument is how any of this stuff, you call it tort reform, the only way that would be helping consumers, it doesn't help any consumer in their individual case, but he claims overall insurance rates will go down.
Yeah, that hasn't been the case in the past 2 years.
It's not been the case.
It's not been the
Insurance rates
case.
have gone way up.
I was just reading how a certain company's CEO made 27 million last year, and they 7 million's on the low end of what they're making. But so you mentioned tort reform. Another part of that was statute of limitations. They made it 2 years to file a negligence case. It's been 4 years for at least 200 years. Long as I know, at least everybody knows, every lawyer knows, 4 years to file a negligence case from when you knew or should have known you had a claim. Now they've put that to 2 years. That's a big change. I haven't done a lot of personal injury lately, but it's some lawyers may not even know that happened. I don't know. And they made a 4-year statute of repose, which that's an absolute bar. You can't sue more than 4 years after the actual incident happened, even if you didn't discover it until 3 years later. Now, DeSantis' side would say, if you had such an injury, how would you not discover it? I mean, there's examples of that. Medical malpractice, you don't know the guy did malpractice until 3 years later, and you find out there's a screw in your back that's broken. And the doctor told you everything was fine, even though it never did feel quite right, but you lived your life. We could have another podcast about how hard it is to get a doctor's appointment in this country. But,
Yeah. So what was the rationale that, as far as you know, is about changing this law? Well, I mean, I know you said that DeSantis' position was that it would reduce overall insurance rates, which it hasn't done. But what was the rationale that they used? Do you remember?
Well, he claimed that it would reduce insurance rates, and he was also concerned 2 years or so ago, about 20 companies did go insolvent in Florida. So his rationality, I mean, he blames, I'm just making DeSantis' argument. I'm not saying I agree with it.
Right.
He calls it frivolous litigation. He thinks the lawsuits like my law firm and others filed is frivolous. And because of insurance companies having to pay out so much money in claims and also to their own lawyers and litigation costs, it's interesting if you do the math, because this is something I meant to mention with Mark before we went on, because you seem to know these kind of stats. There's about 20, what's the population of Florida now? Is it 22 million people?
I don't know the latest. Let's ask
29.
I don't
Siri.
know. We,
What's the current population of Florida? 22,610,000.
Let's say
Very good.
there's about 10 million homeowners policies in the state of Florida. Yeah,
Okay.
the average household has 1.2 people in it or something like that. If you do, okay, so what's 7,000 times 10 million?
It's 70 billion.
70 billion. Now, I know it doesn't all go into profit, but if they're bringing in 70 billion a year. Now, they're complaining that in a couple years ago, because of Hurricane Irma, they paid out a total of 30 billion or something like that. But then they had 5 years of not a lot of hurricane activity. Where'd all that money go? And the CEO is
Yes.
making 27 million a year.
That's a great point. It's something else that I've been researching as well. This concept around reinsurance. Some of the
Yeah.
articles that I saw recently said that as much as 75% of Florida insurance premiums are actually not staying with the insurer, but they're going to a reinsurance company. We're going to look into that more, and we'll cover that in a future episode.
And when you get to the end, Chubb really insures everyone in the world, or Lloyd's of London. I don't, that's kind of above my grade, even understanding all that. But
We'll be right back after a word from our sponsor. There's no better way to show your annoyance with a rogue board than to show up at your next association meeting wearing a t-shirt from ftheboard.com. F the Board has great-looking limited edition t-shirts, hats, and mugs that spur conversation and let you express exactly how you feel while supporting the property rights revolution. Visit ftheboard.com today.
I think that rationale, I agree with you. The rationale was that there were more frivolous, actually, I think the stats that were presented to the legislature was that Florida had 76% of insurance lawsuits in the country originated in the state of Florida. So we were very heavy as far as litigation on trying to reclaim insurance monies. And that was actually an erroneous statistic. That was according to Bernie Birnbaum. He's the executive director of the Center for Economic Justice. And he's an insurance expert. And he said that at the time, the insurance commissioner, who was Altamare in Florida, presented that statistic to the legislature. And he actually wrote them a letter as an expert and told them that that was not correct, that they were not applying the statistics correctly. So I think the rationale was that we were heavily litigating. It was frivolous lawsuits. But there was obviously a move to take away these safeguards. And that really puts us as consumers in a very bad place here, because our insurance has gone through the roof. And now you're telling me that most people are not going to be able to fight the insurance companies at all.
And then you take into account the 60 Minutes feature that they did, where that was out of, I believe, the Tampa Bay area. They had a insurance adjuster who was on camera talking about how he was making estimates, sending them to the insurance company, and the insurer was reducing the estimates and paying out a lower amount, even based on their adjusters. 60 Minutes piece on that was really interesting, because they also found, I can't remember the exact statistic, but it was the majority of instances where the homeowner was getting a reduced amount in terms of their offer based on the estimate of the insurance adjuster. So it seems like it's a systemic thing. It seems that there may be some bad actors in the marketplace. So if there are bad actors, if insurers are intentionally doing this, how does this legislation, it just, to me, it seems to remove all protections that the insured homeowners have. What's your take on it, Jeff?
well, I agree with everything Ann said and what you just said. I mean, it's made it very, very difficult if they are bad actors. I mean, I've had cases, speaking of the 60 Minutes episode, I watched that. They've filed a response to that. They claim that actually more than half the time they adjusted it up. But I've taken the deposition of about 500 field adjusters in the last 8 years, which is their independent adjuster that goes out on behalf of the insurance company. And I've shown them hit their estimate. I expect it to be their estimate. It's not supposed to be a difficult question. I say, is this your estimate? And I've had them look at it and be confused. And I've encountered a couple of those in my case where it was changed.
Yeah.
And the insurance company they have one argument that can be legitimate, which is that the desk adjuster insurance company can adjust things based on coverages. Like the screen over a pool is often not covered, but the field adjuster put that in.
Okay.
But what the 60 Minutes showed, and I've seen in some other cases where it is an actual adjusting down of numbers, like the pricing, they do wrongfully deny and underpay claims. I'm not one of these, believe it or not, despite how I represent insureds in these cases, I'm not one of these people that's just really, really calling these people evil every day of my life. Even historically, when we had the fee shifting, wrongfully deny claims and underpay claims, they issue policies that you could argue, this goes back to day one of law school, they issue actually illusory promises.
And what does that mean?
Well,
what does that mean?
It's like they're promising nothing. The perfect example from law school is you and I'm going to sell you my car. I'm going to tell you, Ms. Hirsch, you give me $20,000 today, and I'll bring you my car. I'll deliver my car to your driveway tomorrow unless I decide not to.
Oh.
Well, I promise you nothing. Well, we haven't talked much about this. And again, there's complexities going on here. One of the jobs of a lawyer is to read the cases and predict the result, not just advocate. And the courts have decided since the 70s that these contracts of adhesion, they're adhesion contracts. Nobody reads them, but they're enforced as if they were dickered over, as if my client actually read and agreed to all that. You might ask.
Most consumers, I mean, it's specific legal language. Most consumers don't have the knowledge and the background in order to really understand what they're signing. Because I know I wouldn't buy a car under the terms that you were just discussing before, should you decide to deliver it.
And the other thing is, you might ask, what could a consumer do? Really, not much, because you don't have a choice. If you have a mortgage, you have to have an insurance policy. Exactly. They're all the same. It's literally a form, HMO3, whatever at the bottom. It's not as if they could have protected themselves. It is take it or leave it. It's frankly sophisticated argument to say that the promise on the roof is illusory. It's not as obvious as my car example. I'll bring in my car tomorrow unless I decide not to. But they say they're not going to pay for pre-existing damages, but they didn't tell my client on day one there's no set of facts under which they would have found coverage for that roof.
Wow.
Maybe if like I always tell clients this too, like if a fire, God forbid, a fire burns your house to the ground, or say you get a direct hit from a tornado that slices your house in half, they're not going to have much choice but to cover that. A lot of our cases, and it's a good thing, the modern building code works. Usually the roof doesn't fly all the way off. Some shingles fly off and water penetrates and people see water leaking. There is an opening caused by the hurricane. But the insurance companies, especially Citizens, they've never seen a wind-created opening. They can't find wind-created openings, even though water's coming in through the roof, and it wasn't before the storm during a normal rain event. Because what happens is, now I'm getting into my engineers, the shingles flop, and that's an opening and water goes through. But Citizens wants to see a hole in the roof like you can see the stars at night. You usually don't have that.
So Citizens, you said, is an arm of the government. So technically it's money that the government collects. And the reason I'm bringing this up is that when I was doing my research, I realized that the insurance companies are for-profit corporations. They're in the business of making money. If they are public corporations, they're in the business of paying dividends. And I think that's the major problem with the insurance coverage. Because when you have some kind of a natural disaster, that shouldn't be a for-profit industry. I think that should be a not-for-profit. And if we have Citizens, which is a pool of money that we fund, and they have a certain amount set aside for administrative costs, the rest should be given out. And I'm very glad that you brought up the fact that the insurance companies, when you sign a contract with an insurance company, that contract is for 1 year. So whatever you pay them, that goes away. I live in a condo community. We pay a very hefty fee for our property insurance. If we self-insured, if we took that money and put that aside every year, and I know that there are stipulations, if you have a mortgage, you have to have insurance. But if we took that money and just banked it or invested it, I think our chances of reinsuring would be probably better than going with for-profit insurance company. What do you think about something like that?
I mean, it's very interesting. It's definitely true. Well, first of all, let me say I don't pretend to be the absolute authority in the mechanisms of citizens because the statute that created them itself is 50 pages long. So that, they collect premiums from each
Mhm.
individual person just as any private company would, but they are considered a nonprofit and that they also get other kinds of funding from Tallahassee. Maybe you know better than me. Now, it's funny because I have clients that have been with the same company for 15 years and they've paid $7,000 a year. So do the math. They've paid 100,000 in premiums and they just need 20,000 to fix the roof. And they're like, if I just had my money back, I could have fixed it myself. If they had just put it into a savings account, they would have self-insured.
Yes.
Now the condo situation is a little bit more complicated.
Complicated. Yeah.
But in the not condo situation, people are always asking. I mean, there are people that don't have a mortgage, so you can go bare. You don't have to have if you have a mortgage, the mortgage company makes you have a policy. They
Correct.
ask me, should I just go without insurance? I never fully give that recommendation because God forbid, let's say you have a $500,000 policy. Again, it really is catastrophic insurance. If it burns to the ground or if a tornado really, really destroys the house, I think the insurance companies pay those. I've never had one of those come to my desk. So it's
Mhm.
like it'd be pretty scary to not have insurance, but it's not helpful in a standard case where the roof gets damaged a little bit and there's water leaks and you need $30,000 to fix. It's kind of like car insurance. You're afraid to put in a car insurance claim when your neighbor dings your door. It's just going to spike your
Right.
rate.
Mhm.
Right.
Homeowners, they claim that a particular claim doesn't cause the rates to go up. The rates they're allowed to charge is governed in Tallahassee with the board and all that. Or health insurance. There's a $7,000 out of pocket every year. And if you have the best insurance and an $80 copay every time, it's not really to cover routine things. And that is what the insurance companies argue in all of our cases is they think it's like routine maintenance type stuff. But the
Mm.
problem with that is the clients have a legitimate claim of 30,000. It's not a million, but $30,000, and there's an $8,000 deductible. They are owed that $22,000. And so
So
coming full circle, I'm worried in the future when we don't have a right to get fees, they're not going to be afraid of our lawsuits.
We'll be right back after a word from our sponsor. The Association Nightmares podcast is brought to you by the U.S. Coalition for Association Reform. USCFAR is committed to changing how associations are governed by shifting the balance of power to better safeguard and advance the rights of individual property owners. The best way to stand up for your property rights is to become a member of USCFAR. Visit us at www.uscfar.com now.
I'm going to segue a little bit. We may be going off track, but the change in law affects all claims against property damage, correct?
Against a property insurer, a first party property insurer, your own insurance
Okay.
company.
Okay. So how does that interplay with the SB4D, which is the Champlain Towers High Rise Act? Now, I know that, I mean, basically they told the people in the condos and co-ops, along the coastlines that they have to, rev up their inspections and their reserves. But the thing is, what happens if there's damage to somebody's condo? I mean, are the insurance companies not going to pay in those cases?
Well, okay. I was
Can
telling
you
Mark
extrapolate
earlier,
on that?
yeah. So there's two claims that could come out of a big problem or damages to a condo, which is the association claiming money for common areas, which supposedly benefits everybody. But you're talking about like in my own condo, my own problems that I have with my own insurance, because you still have to have, and we have several of those cases. We have condo cases too. In fact, a common type of case is water leaking from the upstairs neighbor when their sprinkler broke. I've got one of those right now. I mean, they would be under the same. They have, frankly, there's a lot of homeowner policies that condo owners have less coverage. They don't cover a lot. People never think there's going to be a problem. But all the principles we've been talking about, it's the same exactly in terms of if they had to sue their insurance company, there's no claim to have the attorney fees get paid separately.
So under SB4D, under the new high-rise law, the property owners are paying more money to maintain the property. The insurance companies are probably raising the deductible, I would suspect. I'm not sure. But then there's a risk, just like all other property owners, that they're going to have to sue and they may not get that money back. And that's also the association as well. So that puts us in a really bad place as property owners and consumers. It doesn't seem to benefit us at all.
It really, no, not at all. Again, the only possible argument that DeSantis and others that agree with him would have is if everybody was going to get a massive reduction in their premiums, which we're not seeing happening. Because I mean, I keep using a $10,000 bathroom example. My article talks about, and I think I mentioned earlier, you can go way above that. I mean, if you have a $50,000 or $60,000 claim, speaking of condos, water leak, beautiful Aventura, a $2 million condo in Aventura with beautiful tile and everything. The neighbor upstairs actually hung a TV wrong, which fell, which is what broke the sprinkler, and we're in my case suing him directly too. We do third party stuff too if we have to, but there's insurance coverage just for those water damages anyway. Actually, in that case, in a lot of cases, there's a $10,000 limit. There's a lot of condo policies are not good to begin with. You'll find that hurricanes aren't covered sometimes if you look at it. And it's like
Really?
if you're on a high rise on the water, other than heaven forbid the building falling down, what type of claim would you have? You can have a water leak from your neighbor. I guess you could have water come from your dishwasher, or water comes in through the sliding glass door during a hurricane because it's flying sideways. And as happened to me in Hurricane Irma in 2017, when I was in a different building, I came home from Orlando and found an inch, not a foot, but an inch of water covering my entire floor, got flooded. Even though
Wow.
the glass didn't break and we had put bags, but somehow the water, I think the glass bows but doesn't break and water comes in and whatever. And at that time I was a renter actually, which is slightly different, but my renter policy didn't cover hurricanes. Like what else would you we could talk about there's the issue about how they don't cover flood and everyone says you got to get a flood policy. That's a policy level thing. They could decide in Tallahassee or at the national level that all insurance policies cover
Include flood.
if a hurricane caused the flood. Every normal person that didn't go to law school was like, what do you mean a hurricane caused the flood? And I have to explain to my clients, they literally demarcate if there's a flood, you can see a flood line on the wall where the water was up. They won't pay for the drywall, but they might pay for the roof. We're seeing that right now with Helene, where it's
Yeah,
all
in the
flood and not as much.
Carolinas. Yeah.
Okay. I got off track, but on her, your policy,
No, that's good. That's good.
if water floods your condo, even if it's a luxury condo, it may cost $60,000 to put all new floors. Yes, 50,000 more for the drywall. I don't know. Maybe you have $100,000 claim. That's at the bottom limit of what a lawyer could do on contingency when it takes $50,000, as I said, to get through a jury trial. We always have to have the threat that we'll take you to trial if you don't pay. They don't pay. Nobody cares about demand letters in all kinds of contexts in this world. You might realize I'm always telling clients, I get calls from clients, potential clients all the time on all kinds of different things, not just the insurance stuff I do. Can I write a demand letter? I'm like, I'll write you a demand letter. They're not scared. Even after we file a lawsuit, they're still not scared. We have to fight with them for 3 years. They're not going to settle until I used to say on the courthouse steps, but a lot of times it's in the courtroom after you pick a jury in the trial. Then it might settle. Then they make an offer. Okay. They're not afraid of a trial when we're not going to have our fees paid separately. I know I sound like a broken record. But how it relates to condo, I represent a client right now who's got about a $2 million condo in Aventura. The reason the condo is beautiful, but the reason that condo is worth $2 million is the location. The actual size of the condo is not gigantic. So, we have estimates 100, 150,000 to redo everything. He does have a big deductible. We do have a lot. We're representing him. We have a filed lawsuit. We're hoping to get money from the neighbor. I mentioned that as well, but there are a lot of cases where the damages really are $30,000, $40,000, and that really is getting to a level where lawyers don't, like personal injury lawyers represent on contingency because they might get a $10 million verdict.
Right.
And the other thing which my article addresses, and not to denigrate any of them, if you get a $10 or $40 million verdict in a personal injury case, 30 million of that might have been pain and suffering or punitive damages. Plaintiff's entitled to that, but that's kind of a number. You can't figure that out with a calculator. Another reason for the fee shifting statute in insurance, recognized since 1893, is we're talking about repairing real property. The money needs to be used to repair it. So even, let's say I do a great job representing my client and the other insurance company is reasonable or they're afraid of me or something. And the client really does need $50,000 to do all the repairs. That's what defines the damages. Well, I have to take 33% of it, and then the public adjuster, there's a public adjuster and they get 10 or 20%. By the time you're done, a $50,000 settlement, the client gets less than 25 of it in their hands, but they really did need 50. They cannot do the repairs. So actually it's interesting because banks, lenders have an interest in getting repairs actually done. That's why they make you have a policy. Actually, they kind of like, actually we're a title state in Florida, but everyone knows if you have a mortgage, the bank owns it until you pay it off. Stop paying it and find out what happens.
Mhm.
So it's very, very interesting. And again, I haven't been until recently looking so much at the political arguments in Tallahassee. The law comes to me and I just argue what it is. But it's interesting. I've recently started looking at it because the concerns you're raising, we're very concerned about it. We're thinking about maybe we need to get into some other areas of law, quite frankly.
Yeah.
to pay the rent.
So if someone has an insurance claim and they want to engage your services, what's the best way for them to prepare? I mean, what would they need to bring with them? How would they approach you?
Well, starting on day one, take pictures of everything or videos. Everybody's got a phone now. Video, contemporaneous videos help. Write everything down. Gather your receipts if you can. A lot of clients, their kitchen got ruined and they had just put in a new kitchen 3 years earlier. Well, if you have the receipts that show me you paid 50 for that, that's helpful. So, it frankly is not helpful if you have your cousin do the repair and pay him in cash.
Mm.
I'll tell you, it's better if you do it the right way with a real contractor, document it.
So let me see if I can take this a little further. So let's say I have damage to my home and I have an insurance policy. So the first thing I would probably do would be to call my insurance company or my agent and say, I had a water leak or whatever, and I'm putting in a claim for it. Should they contact you with the new law in place? Should they call your office and talk to you guys first before they do that or after they do that? What's the best?
I'm sorry. Yeah. I actually don't think so. And I said that, it's funny. Here's where I agree with DeSantis. You know that Jimmy Patronis is actually sending out texts to people saying, call the insurance company, don't call a lawyer. It doesn't hurt to do that. That's what we call a self-report. Historically, both before and after the new law, I'd say 30% of our clients are self-reports. That's a good thing. That gives us the argument. You gave the insurance company the chance to do the right thing. You got the runaround from the insurance company, then you had to hire a lawyer. So I actually wouldn't say call me first. I actually would agree. I know Citizens gives people, I think they have magnets, like refrigerator magnets with their 1-800 number, call us first. I don't disagree. Number one, you call it in, you're gonna get a claim number assigned right away, and you've given them, because you have to give prompt notice. That's another issue. And it's become harder and harder in recent years. If you wait 8 months or 3 months, they can deny that just for not giving prompt notice, because it's like, hey, if you had these damages, why'd you wait 8 months to call us? Historically, we had cases reported as much as 3 years late, and we survived summary judgment and still got good results, but it's become harder. There have been it's not only the legislature in Tallahassee, there have been court cases that have more and more enforced some of the language about prompt notice.
What is a prompt notice? What's the time frame legally?
Well, you know what? Prompt means immediate.
Okay.
Like within reason. Like, when Hurricane Irma came, everybody evacuated to Central Florida. Then you couldn't get any gas. That's the first time I found out about that app Waze that was purporting to tell which gas stations had gas. Got back to Miami 5 days later and found my apartment flooded. You don't have to instantly pick up the phone, but if you wait 8 months or 2 years, it does give them an argument. If it was if you had a catastrophic injury, if you broke your leg, you wouldn't wait 8 months to tell the doctor.
Okay.
So, be careful. I was going to say, it's not like you're going to lose the case. I don't think they usually get people to make admissions on the phone because they'll send out an adjuster. I mean, you want to report your claim as soon as possible. They can call us first. We have a system in place where if we get hired, we get the claim reported that day. But then the field adjuster is going to come out, the insurance company's adjuster, and do an inspection. And, well, I'm rambling on and on, but they'll often act like they're on your side when you're in your driveway, but then you get your denial letter in the mail 2 weeks later. Because number one, the field adjuster isn't making the decisions when he's out there. And number two, it's a human what I don't know what the psychological word is, but if you're standing in front of somebody, you want to be nice to them, and then
Yes.
it's easy for them to leave, and then the denial letter comes in the mail a week later. What's the word for that? I can't.
I don't get
Denial?
from
Avoiding confrontation.
psychology. No,
It's just avoiding confrontation, I guess.
sure,
Yeah.
sure.
Yeah.
Yeah. So what do you think we can do? I mean, we're stuck with this legislation now. Can we modify it? Can we change it? What
Yeah,
do
what
we
should
do as
property
just,
owners do with this?
yeah,
And then in the near term, really all you can do is call and write your legislator, because this is a change made in the legislative branch of government in Tallahassee. It's interesting because a lot of the people that live in Tallahassee, I think they kind of escaped it, but people were saying they're going to get really slammed by Helene or Milton, which one of the ones that came through.
Yeah.
Not that you wish bad on anybody, but it's like their own insurance companies will deny them, and maybe then they'll see, oh, this is what it's like. What they have done in Tallahassee has really, really hurt an individual person's ability to sue their own insurance company with a lawyer representing them. Let's just say that.
that's a major point you just made. Can you say that again?
If I could be more concise, which I'm sometimes not good at, the major change in Tallahassee, taking away the fee shifting, has very, very severely hampered any individual person's ability to sue their own insurance company for an insurance claim. And I said it better the first time. It's harmed their ability to sue their insurance company with a lawyer representing them. Anybody can go run down to the court and file their own lawsuit. You don't have to have a lawyer.
Yeah.
If your business should do, that's another thing. But these arguments were made in the workers' comp things too. Even if a claim has a $6,000 value, it's still very sophisticated arguments. There's lawyers on the other side armed with all this policy language about why they don't have to pay, and they're getting paid by the hour to fight you. So not to toot my own horn, but you wouldn't have much of a chance against an insurance company if you didn't hire us or some other lawyer.
Yeah.
Everyone knows that.
Just on the standpoint of procedural alone, they can get your case kicked out, as happened to Ann.
That's what happened to me.
Just on procedure. So, Jeff, what's the best way? What's the best way for our audience to reach you if they want to speak with you, get some information?
Well, I'll give you my firm's phone number, which we have a receptionist answering the phone, whereas I can't always answer my phone. So I'll give you that one. 305-760-2314. I had to look down at a paper because even when I'm in my office, I just use my cell phone like my direct line.
No one remembers phone numbers anymore.
That's our firm number. I don't know my wife's number. I know I say call, everyone knows. I still know all my friends' phone numbers from fourth grade, 788-7124. My friend. I was telling my daughter, my kids don't know my own phone number.
Yeah.
I don't know anyone's phone number.
Is a 6-year-old kid supposed to be able to tell the school one of their parents' phone numbers? Like, when are they supposed to know that? I was thinking about that the other day.
Yeah.
Like, I grew up, of course, with phones with that wiry thing attached to the wall.
Yeah, I did too.
Of course, dialing.
The rotary dial, yes.
Jeff, what's the name of your law firm?
Litigation and Recovery Law Center. I should have given you the website too. So losslitigators.com.
Losslitigators.com.
No dash. LOSSLITAGATORS.com. Losslitigators.com is the firm's website. I have my own website where you found that article. I don't really want to plug that. I work for that firm. On my own website, I kind of have this blog that I write for fun.
Yeah, it's a great blog. We encourage you to continue writing it because, for us, even though as a consumer, to me, there's a lot of jargon in there that's a little dense. It's really not for a consumer audience and, or at least not somebody that's not sophisticated in law. Some of it was a little dense to read, but I was like, wow, if this says what I think it says, it basically means that as a homeowner, you're really not incentivized to you've disincentivized the insurance company from actually paying claims is what it seemed like. And it's disincentivized any attorney from ever taking on any case unless it reaches a certain size. So most of the cases don't, I think you said it was $50,000 or higher. So most cases aren't of that size.
Well, everything you said is exactly right. There's no, I'm saying it takes $50,000 in fees and costs to do a trial. You need a case worth $100,000 to even make it somewhat reasonable. Remember, almost always there's going to be a public adjuster involved too. They hire them before they hire us. They have their own deal, 10 or 20%. Again, back in the personal injury context, and maybe I'll get myself in trouble because there's high volume practices, I guess, that are doing PIP law. I've never really done that and turn them over. But I always think the PI, like when you see those billboards, Morgan & Morgan, My lawyer got me 800,000. Well, the client only walked away with 350 by the time all that was done. 40% fees, the cost and everything. And it was, so at least they got to 300,000. The world's not perfect. There's transaction costs. It's a tighter margin when you need $40,000 to repair your home when you only get 20. And these people don't have the money to actually fix their roof unless they get paid.
Yeah. And then for sure, their insurance carrier will probably drop them, and they're going to pay higher rates next year and the year after, et cetera.
And we have claims against them for that, but they are allowed, they basically, we accuse them of bad faith when they drop people with a pending claim, file what's called a civil remedy notice. Truth is, it's very hard to win those cases. They don't have to renew people. They're allowed to non-renew people. We can't really prove they did it because they filed this claim. They say, oh, we non-renew. They don't just drop you, they non-renew you for the next year. I was going to say, so the blog, it is interesting because I write that blog. It is kind of written for other lawyers to read as I think about it.
Mm-hmm.
And I don't really, maybe I should have more of a consumer looking focus on there, but I kind of was just doing it for fun recently. And yeah.
I think it's great. It's,
Yeah,
you know,
it is great.
Yeah, it really, and I've only really dived into that one article. I see that you have a lot of other great articles there, which, you know, perhaps we'll talk in the future about some of those others. So really, I appreciate you joining us, Jeff. This was a really interesting discussion. It's very, to me, it's a very scary place for homeowners in Florida to be, and most of us don't even know we're in the situation. So that's why we thought it was such an important subject to have you join us on. So thank you so much for the work that you're doing and for helping us to raise awareness about this issue.
No, again, thank you for having me on. It's my pleasure. Had fun. Maybe we'll do it again.
Absolutely.
Yes, that would be very nice. That'd be very nice.
Thanks for joining the Association Nightmare Podcast. Be sure to like, share, and subscribe. We'll see you again soon.